Good morning, everyone. I hope I am audible to you all. Today, the notification of MP has come, Civil Judge Junior Division. In the afternoon only, I saw the notification and the exam has come and it has 62 vacancies for general. Probably the exam will take place in the month of February or March. So start preparing for it. Don't waste your time. Frame your answers accordingly. The subjective questions which we are providing to you will help you in each and every exam, not only particularly DGS. We are not targeting any particular state. So we are not targeting any particular state. It is for every state. The subjective question which we are framing will help you in every mains exam. So try to make every answer which we are giving you, and in fact जो material के back side में भी questions दिए गए हैं वो previous years के ही हैं, उन सबको बनाइए, and 2 pages for every answer is sufficient. उसमें बहुत मटेरियल आ जाता है तो यू डोंट नीड टू मेक इट मोर लेंथी, क्योंकि एंड टाइम पे रिवीजन होना फिर पॉसिबल नहीं है. इफ यू विल मेक द मैटर लेंथी देन इट विल क्रिएट प्रॉब्लम फॉर यू एट द लास्ट मोमेंट. So fasten your belts, which we say, because the notification has come. Now every day, like we say that the countdown has begun. So start preparing. Check the syllabus, subjects, areas from which questions have been asked in previous years, and try to solve objective and subjective questions of every topic, of every main topic. Yes, you must be qualified. Your degree of LLB must be done for the MP exam. So if you are LLB graduate, then you can appear in the exam. No final semester student can give MP exam. So your graduation must have been completed. Start preparing for it. Don't waste time. Today we are here to discuss the assignment number 9. The question must have been uploaded in the app. You all must have seen the question, and I think you have solved it also. And it is good if you have solved it, but if you have not, then please solve it, frame your answer. Even if it is wrong, then no worries, but make sure that you solve all the questions. At least make a briefing of all questions. So assignment number 9. The question was very small and easy to understand. It was not very much lengthy. Here were partners of a firm. Suppose A and B. We are taking an illusionary example because in the question it is not mentioned how many partners, but to understand the question we are taking A and B as partners. Suppose the parties were partners of a partnership firm. They ran an institute. In 2004, one of the partner, for suppose A, sold his undivided share to the other partner, to B. Now, for claiming the balance of sale in 2004, the sale took place, and for claiming the balance of sale, a suit was filed in 2004 only to get the payment of price. The suit was decreed. The suit was decreed by the trial court. Now, another suit was filed in the year 2007. Second suit was filed in the year 2007. Now, what was the second suit for? Now, the another suit was filed in 2007 for the rendition of accounts of partnership firm for the period year 2000 to 2004. It was for the setting of accounts. It had nothing to do with the agreement of sale which took place in 2004. The second suit was filed in 2007, which was for the clearance of accounts for that partnership firm. Because the partnership got dissolved in 2004 as stated in facts. Now the question which comes to us is whether the suit is hit by Order 2, Rule 2 or not. The first suit was filed in 2004 for the non-payment of price. To decide each and every question which comes to us or which comes to us before in paper or anywhere we are practicing the question, first of all, the clearance of facts is very necessary. The first suit was for the non-payment of price for the sale which took place between A and B. And the second suit was filed in the year 2007 for the setting of accounts of the business which was there between A and B from the year 2000 to 2004. So these are the two causes. Now to see whether the suit is hit by Order 2, Rule 2 or not, we have to see what is Order 2, Rule 2. I hope you are clear with the facts. Now to see whether the Order 2 only. Order 2, Rule 1 and 2. This we need to understand. So while we frame a suit, what things we keep in mind? Pleadings, form of plaint, and thirdly, parties to the suit. These are the three things which we see when we frame a suit. Now, what Order 2, Rule 1 says? It says that every suit shall as far as practical be framed to afford ground for final decision upon the subjects in dispute and to prevent further litigation. इसका क्या मतलब है कि सूट ऐसा बनाओ कि फाइनल डिसीजन आ जाए और फर्दर लिटिगेशन ना करनी पड़े. जो भी रिलीफ आपको मांगने हैं, जो मांगे जा सकते हैं एक सूट में, वो आप मांग लीजिए ताकि उससे कोर्ट एक कंक्लूजन पर पहुंच सके. सेकेंड रूल क्या कहता है? सूट टू इंक्लूड द होल क्लेम, यानी कि उस सूट के अंदर वो पूरा क्लेम आना चाहिए जो कि प्लेंटिफ डिफेंडेंट से मांगना चाहता है इन रिस्पेक्ट ऑफ द सेम कॉज ऑफ एक्शन. द कॉज ऑफ एक्शन इज द कीवर्ड हेयर कि सेम कॉज ऑफ एक्शन पर मांगा जाए. बट अ प्लेंटिफ में रिलिंक्विश, वो ऑमिट भी कर सकता है कुछ मांगना जो वो नहीं मांगना चाह रहा है या किसी रीजन की वजह से उसको छोड़ना चाह रहा है, any portion of his claim in order to bring the suit within the jurisdiction of any court. For suppose the plaintiff wants to claim for 2.5 crores, and now he has to file a suit. So to keep his suit in the jurisdiction of district court, he files the suit because the amount claimed is 2.5 crores. So for that he need to file the suit in high court. So to make the jurisdiction of his suit in the district court, he can file in district court by claiming only 2 crores or less than 2 crores. So that जो उसका suit है वो district court की jurisdiction में आ जाए. तो ऐसा वो relinquish कर सकता है. बट जो उसने omit किया 50,000 वो बाद में claim नहीं कर सकता because he has relinquished that portion. वो उसको बाद में नहीं मांग सकता except, now you come to this line, except with the leave of the court. It means if he has taken leave of the court, if he has taken the permission of the court, then he may ask for more than one relief in respect of same cause of action. Further also, अगर leave लिया है, then he can. अगर नहीं लिया है, then he cannot. Good evening, everyone. So, coming back to the point, we have discussed Order 2, Rule 1 and Rule 2. Basically, Order 2 is based on a maxim, interest republicae ut sit finis litium. It means all claims to the same cause of action must be seek from the court at once. Why to make the litigation so complex that we file different suits on the same cause of action? What we can, जब हम किसी shop पर जा रहे हैं, if we are going to buy something from a mega store or something, then we pick all the things. Or do we go one by one to take different things? So if we are moving ahead in same cause of action, then why should I go again and again to the court for different reliefs which I can claim in one suit only? So if the relief is based on same cause of action, if the relief is based on same cause of action, then I have to ask it to the court in once only, not again and again. I hope this point is clear to you. Now for this, I am taking an example, short example. A is removed from his job . A is a person, A is removed from his job. He files a suit in court. A को job से निकाल दिया गया है and he files a suit in court. Now he prays for declaration that his dismissal is wrong. यानी कि उसको गलत grounds पर निकाला गया है. His dismissal from the concerned authority is absolutely wrong, and therefore he asks for the same from the court, that please declare that my dismissal is wrong. But he did not ask for the arrears of his salary due. The period in which proceedings were going on and his salary was not given, he did not ask for the same in the same suit. His salary was due, but he only asked the court for the dismissal, that his dismissal is wrong, and he did not ask for salary dues. Now you only tell me that can he file another suit for the salary due? Now can he ask the court, can he go to the court again for the salary due? Because he could have claimed this in this suit only, that my dismissal is wrong and please make sure that my all dues should have been cleared in this suit only. So this is how we need to see that the cause of action is same or not. Understood? Now coming back to the case which we were discussing, we have seen the purpose, we have seen the object, that no defendant should be vexed twice, should be brought to the court twice, and we should prevent the splitting of claims and remedies which could have been asked in the same suit filed by the plaintiff. Now in this we have a leading case, Gurbaksh Singh versus Bhuralal. AIR 1964. In order to attract Order 2 Rule 2, we need to see few things. That this second suit was in respect of same cause of action. ऑर्डर 2 रूल टू अट्रैक्ट कब होगा? जब जो सेकंड रिलीफ मांगा गया है कोर्ट से वो सेम कॉज ऑफ एक्शन पर बिल्ड हो. Secondly, the plaintiff is entitled to more than one relief in same cause of action. Actually, the bar of Order 2 Rule 2 is technical in nature. And it has to be seen whether the cause of action is same or not. We have to see from the pleadings. We have to see from the pleadings that whether the cause of action is same or not. Not from the merits of the case as have been decided by the case कि पिछले केस में merits क्या रहे वो हमें नहीं देखना है. We have to see the pleadings to decide whether both these suits are built on same cause of action or not. So now coming back to the case, what was the conclusion? कि in which we said that the first suit was on non-payment of price, and the second suit was non-settling of accounts. These were the points in which we had to see that whether Order 2 Rule 2 is attracted or not. So, in Alka Gupta versus Narendra Kumar Gupta, 2010, 10 SCC 141 is the citation. It was held that both the causes are different or distinct, and the reliefs are not based on same cause of action. The facts which have been taken in this case are of Alka Gupta versus Narendra Kumar Gupta. And what the court said that both the causes are distinct, दोनों causes distinct हैं, different हैं. Therefore, the bar or embargo of Order 2 Rule 2 is not attracted here. And plaintiff can file another suit for the same. So I hope What should be barred by Order 2, Rule 3? Mukta Gupta? I have not understood your comment. What should be barred by Order 2, Rule 3? Are you talking about the example which I gave earlier? Here in the assignment number 9, the question is related to Order 2, Rule 2. The purpose of giving the example which I gave, the dismissal, was to explain you that what could have been claimed earlier. If not claimed, then it cannot be claimed later on. I hope you are clear with my points. Please write in the comment box if you are cleared with the question. Yes, correctly, Gyanendra. The bar of Order 2, Rule 2 won't apply because the claim was different and was not based on same cause of action. For determining the same cause of action, we need to see the pleadings and not the merits of the case. It has been said by Supreme Court in various cases that to determine the same cause of action, we need to see the pleadings, we need to see the averments by the parties and not the merits of the case. Whether the same is based on, whether the reliefs which are there is based on the same cause of action or not. Because in different cause of action, you give different evidences. So that is how you need to make a slight clarification that what is the cause of action and how to differentiate that whether it is based on the same cause of action or not. Wonderful. If you have understood the assignment number 9, then so make sure that you attempt the other questions also which we have given to you. And I'm forming another questions also, another subjective questions which can clear your concept more and move in. When we solve the such questions, such subjective questions, then it basically clears the technicalities in which we can be struck if we are in exam. Yes, Abhishek Tiwari. Because if we are giving different evidences in the court for the suit we have filed, then how can the cause of action be same? So it can be one parameter that if we are giving different evidences, yes. I think all have understood that Order 2, Rule 2 won't be applicable. The embargo won't be attracted because both the cause of action are different. By attempting such questions, you clear your concept more. So I would advise you that even if you are getting the model answer for the same, please try to attempt the question honestly by not opening any book. Try to write the answer on your own. Even if you are writing 4 lines, then write it on your own. Don't see the book, don't see the provision. You will write wrong once, twice, thrice, but at the 4th attempt, you will write right. So this was the case. Yes, Muhammad Khalil Khan. Muhammad Khalil Khan was the case in which it was said, correctly pointed out. So it is the duty of the defendant basically to bring this point, uh, before the court, that the same have been asked earlier also. So I hope the concept is clear. Yes, Mohammed Khalil judgment was there. Yes. If you have read all these judgments, then Order 2, Rule 2 is clear. So I think the today's session is done. Tomorrow I'll be back with the another subjective question and maybe some different question also, which I have not even given in the app also. So I can take the another question also to make it more interesting. Thank you everyone. I hope you are all clear with the order 2 rule 2 question and the concept as well. Now the sir will resume the class.
तो मेरे एम्बिशन के मित्रों, आप लोग कैसे हैं? How are you people? I hope you must be doing great. Okay. So this is the thing. बहुत अच्छा, बहुत अच्छा. क्लास में बस इतने ही लोग आते हैं. मैं भी खुश हूँ, ठीक हूँ. बस मैंने सोचा काफ़ी दिन हो गया तो आपसे हालचाल थोड़ा पूछ लूँ. Let us interact with each other. Otherwise, बहुत दिन ना मिलो तो दोस्ती में भी दरार पड़ने लगती है, नहीं? एमपी का नोटिफिकेशन आया. बढ़िया है. एमपी का भी एग्ज़ाम देंगे. मैंने कहा आप लोगों से बातचीत करूं, बहुत दिन हो गया ना बातचीत किया. मैंने कहा लेट अस टॉक वन डे. अब इतना पढ़ रहे हो आप लगातार, यू हैव बीन नाउ studying, so I thought that there should be little break in between and I should come and I should talk to you. बिल्कुल बिल्कुल वर्मा जी. अब आप सभी से मेरे को जानना है कि भाई सब कुछ कंट्रोल में है ना आपके? कोई दिक्कत तो नहीं है? If you have any issue, please feel free to tell me. I am your guardian, I am your mentor, I am your guide, coach. Hmm. I just ask you a question. Everything is in your control, everything is happy. Happy to read this kind of comments. All right, all is well. Good. God bless you. So, chaliye, now I have the feeling that everything is all right. I am not worried. Because sometimes you hear something which you do not believe. Oh, so you, आपके साथ भी ऐसा होता होगा. I hope so. Somebody may come and somebody may say something which will really now shatter you that how it can happen. I tell you a very short story. I have done a certificate, I can fill the form. Yes. Suggestion on time management, I'll give you. Okay, that's really great. That is really great. So I was saying, now I saw your comments, I'm looking into your comments. Mm, suggestions on time. I'm blessed with mentors like you. Okay, very much happy, Sandeep sir. Mm. Is this clear, my dear friend? Now just looking to your comments. All right. So you need motivation in between. I am there for you, my dear friend. Don't worry. I'll teach you also, and I'll a little bit give you my छोटी मोटी जो मेरे पास बुद्धि है, छोटा मोटा जो मेरा अनुभव है, छोटा मोटा जो मेरा ज्ञान है, जो भी मुझे पढ़ाना आता है, जो भी मेरे पास विचार हैं, मैं आपको उससे पल्लवित पुष्पित और गाइड करने का प्रयास करूँगा। तो आप चिंता ना करें। देखिए, हर मनुष्य में बड़ी असीम शक्ति है। आप में, हम में, बस उसको जानने समझने की ज़रूरत है। होता क्या है कि हम राह में चलते-चलते ना इतने नकारात्मक चीज़ों से टकराते हैं कि हम भी नकारात्मक हो जाते हैं। मैं वही आपको कहानी बता रहा था। मैंने एक बार वाकया हुआ, एक बच्चे को ना क्लास में मैंने सेक्शन 27 इंडियन एविडेंस एक्ट पढ़ा दिया। बड़ा लंबा पढ़ाया। सेक्शन 27 नीड्स दैट काइंड ऑफ एलैबोरेशन, एक्सप्लेनेशन। और 28 मैंने क्विकली पढ़ा दिया। अब वो विद्यार्थी जो है घबराया, शर्माया, उलझाया, अपने आप को उलझाया। फिर मेरे पास आया। फिर वो मेरे पास आया और मुझसे बताया, वही वाह, अन्नपूर्णा भास्कर, ये आप तो बड़ी अच्छी बातें बताते हैं। यार आओ किसी दिन मिलो तुम लोग मेरे से। आ, हम लोगों को प्रेरित करने का काम करते हैं, अपने राज्य के लोगों को भी प्रेरित कर रहे हैं। अब देखिए, हर व्यक्ति का जन्म कहाँ होगा वो तो उसके क्षेत्र में नहीं है, बट कहते हैं ऐसा कि जननी जन्मभूमि स स्वर्गादपि करियसी। जननी और जन्मभूमि से बढ़कर के स्वर्ग भी नहीं होता है। तो मैं भारत का रहने वाला हूँ, भारत की गीत सुनाता हूँ, बट मेरा जन्म भारत के एक प्रांत में, जिसको बिहार कहते हैं, वहाँ हुआ था। तो मैं बिहार के लोगों को प्रेरित करने का एक कार्यक्रम कर रहा हूँ। अभी दिल्ली में भी है 25 दिसंबर को, एनडीएमसी कन्वेंशन सेंटर में, क्रिसमस के दिन। तो अपने छोटे छोटे उपायों से, अपने छोटे छोटे कदम से आप सबको प्रेरित कर सकते हैं, लेकिन आपको राह में निगेटिव लोग मिलेंगे, आप कुछ नहीं कर पाओगे उसका। हर जगह होते हैं। और मैं आपको बताऊं, देखो हुआ क्या कि मैं अपने एक जानकार को एक दूसरे जानकार से मिलवाता हूं इस कार्यक्रम के सिलसिले में। बड़ी अच्छी मुलाकात होती है, बड़ी अच्छी बात होती है, बड़ा अच्छा सिलसिला चलता है। कुछ दिनों के बाद वो व्यक्ति जो मेरे थ्रू उस दूसरे व्यक्ति से मिला था, वो सीधा संपर्क करता है। कोई खराबी नहीं है, बट फिर एक मुहिम आगे बढ़ता है, कई सारे लोग उसमें जुड़ते हैं। चूंकि उसमें मुहिम में अग्रणी व्यक्ति हूं एक, काफी लोगों को मैं जोड़ता हूं। अब वो जो व्यक्ति है, दूसरे व्यक्ति को जिनको मैं जोड़ता हूं, उनको अपनी ओर खींचने के लिए भोजन पर बुलाता है, ये करता है, और मुझे नहीं बताता है। किसी को किसी पर भोजन पे बुलाने पे कोई बुरी बात नहीं है। मैं आपको जीवन का लेसन सिखा रहा हूं। बट लेकिन लेकिन भोजन पे बुलाना कोई बुरी बात नहीं है, लेकिन मुझे क्यों नहीं बताता है? होता क्या है आखिरकार? शायद उनमें ये नकारात्मक भाव आ गया होगा, इस व्यक्ति के द्वारा मैं सबसे मिल रहा हूं तो ये व्यक्ति हमेशा हावी होगा, इसलिए इसको दूर कर दो। एक तो ऐसा नकारात्मक विचार आ जाता है आपके पास। दूसरा, जैसे मैं आपको अपना वाकया बता रहा था, मैंने धारा 27 एविडेंस एक्ट का बड़ा अच्छे से पढ़ाया, और सेक्शन 28 बड़ा हल्के में पढ़ाया, और क्या डिमांड है 27 की, क्या डिमांड है 28 की, शायद आप समझते भी होंगे। अब वो व्यक्ति, वो बेचारा विद्यार्थी मेरे पास आता है, परेशान होता है, कहता है सर आपने सेक्शन 28 तो पढ़ा है। ये कई बार मेरे साथ हो चुका है। मैं आपको इसलिए शिक्षा दे रहा हूं कि आपको ये सबक लेनी पड़ेगी। इस खेल को मैं बहुत दिन से खेल रहा हूं। तो दोस्तों, मेरे ऊपर भरोसा करो, मेरे निर्णय पर भरोसा करो। क्या चीजें जल्दी पढ़ानी है, क्या चीजें देर से पढ़ानी है, इसका निर्धारण हम करते हैं, करेंगे। आपके बेहतरी के लिए आप विश्वास करो। आप बहुत ज्यादा दिमाग लगाओगे, बहुत ज्यादा उस पर आप नुक्ताचीनी करोगे, तो इससे नुकसान आपका होगा। अब आप सेक्शन 28 इंडियन एविडेंस एक्ट का देखो और सेक्शन 27 देखो, दोनों एक ही तरह के सेक्शन है। आप हर सेक्शन को एक ही प्रकार से पढ़ोगे? क्या आप कॉन्स्टिट्यूशन में आर्टिकल 21 जैसे पढ़ते हो वैसे 23 पढ़ते हो? आपके लिए तो दोनों आर्टिकल एक ही हो गया। आप कहोगे आर्टिकल 23 तो आपने 5 मिनट में पढ़ा दिया, 5 मिनट भी शायद मैं नहीं लूंगा, और 21 को 5 घंटे में पढ़ाना पड़ता है। तो कहाँ 5 घंटे, कहाँ 5 मिनट, कैसे होगा ये? क्या है ये? मित्रों, आपको मैं स्पष्ट कर दूं कि 21 deserves 5 hours and 23 deserves only 5 minutes. Not even 5 minutes. Now, this learning, this information may not be available at the outset to you or to many people. Believe me. अब यदि आप कहें कि सेक्शन 23 या आर्टिकल 23 ऑफ कॉन्स्टिट्यूशन, व्हाई डिड यू नॉट टीच इन 5 hours when you taught this section 21 in rather article 21 in 5? How can I answer? I am answerless. मेरे पास तो प्रश्न का जवाब ही नहीं रहा, मैं तो निरुत्तर हूं, मैं तो अज्ञानी हूं। मैं कैसे जवाब दूं इस प्रश्न का? क्या उत्तर दूं? और मैं उत्तर दूं तो यदि आप सुने नहीं तो मैं क्या समझाऊं आप? तो मेरी सलाह है, मेरी सीख है, मेरा सुझाव है कि आप मेरी बातों पर चलो। हाँ, यदि आपकी कोई ऐसी इच्छा है, आप मुझे समझाना चाहते हैं, उसके लिए आप मुझसे संपर्क कर सकते हैं, मैं आपसे समझने के लिए तैयार हूं। बट मैं आपसे समझने के लिए तो तैयार हूं, लेकिन आपको मेरी बात समझने के लिए सदैव तत्पर और तैयार होना पड़ेगा। सदैव तत्पर और तैयार रहना पड़ेगा। मैं जो कह रहा हूं शायद आप वो बात समझ पा रहे हैं। अब इस बात को बड़ी गहराई से, बड़े ध्यान से, ये आपके हित का सुझाव है, मेरे हित का नहीं है। ये आपके हित का सुझाव है, ये मेरे हित का सुझाव नहीं है। इज दिस ऑल राइट? ये मेरे हित का सुझाव नहीं है, आपके हित का सुझाव है। अब मेरी बात को शायद समझ रहे होंगे। तो इस प्रश्न पे, इस बात पर ज्यादा नहीं जाना है कि हमने कौन सा टॉपिक कितने देर में पढ़ाया, वो मेरा डिस्क्रिप्शन है। आप यदि मुझे ये सब चीजें भी बताने लगोगे तो आपके लिए समस्या खड़ी होगी, मेरे लिए नहीं होगी, क्योंकि मुझे तो जैसा आप आदेश करेंगे मैं कर दूंगा, मुझे कोई समस्या नहीं है। बट उसमें होगा क्या कि आपको ये ज्ञान नहीं हो पाएगा कि व्हाट इज इंपॉर्टेंट, व्हाट इज मोर इंपॉर्टेंट एंड व्हाट इज वेरी लेस इंपॉर्टेंट। आप ये बाइफरकेट ही नहीं कर पाओगे। जैसे एक उदाहरण बताता हूं, बाय वे ऑफ एग्जाम्पल। I told you even earlier, if you remember correctly, that in all procedural law, the trial is the most important part. In CRPCC section 154 to 265, and in CPCC section 9 to 35B. And see in this order 1 to 20. अब आप यदि मुझसे ये कहने लगे कि नहीं 23, 24, 25, 26, 27, 28, 29, 30 ये सब उसी प्रकार से पढ़ाए जाएं जैसे आपने ऑर्डर 2 पढ़ाया था, तो आप अनायास अपनी ऊर्जा का क्षय करोगे। Your energy will be wasted because you do not understand what is more important, what is important, and what is less important. This is what is the learning of law. तो मैं जो आपको बातें बता रहा हूं, मेरी बातों को ध्यान से समझिएगा। सीपीसी में आपको भी पता है ये ऑर्डर 23, 24, 25 ये सब तो एंसिलरी चीजें, 26, 27 क्या है गवर्नमेंट वाला ऐसा मेरे ख्याल से। इस सब में क्रक्स कहाँ है? स्पेशल सूट्स आर सूट्स ऑफ ए स्पेशल काइंड, देयर मे बी लिटिल बिट डिफरेंस हियर एंड देयर, but beyond that, is there any important thing in spatial suit except in some special cases like interpleader suit, like indigent suit, like summary suit, friendly suit? There may be a little bit important, otherwise it is not. ये तो एक प्रक्रिया बताता है कि भाई इसमें थोड़ा बड़ा डेविएशन, स्पेशल सूट है, रेस्ट विल रिमेन सेम, बट देयर विल बी समथिंग स्पेशल एज वेल। तो परेशान नहीं होना है, निराश नहीं होना है, नाराज नहीं होना है, आप बातों को समझ, क्योंकि आज नहीं समझिएगा ना आप तो आपको ये चीजें, यू विल अंडरस्टैंड दिस ऑब्वियसली, जैसे मैंने समझा, हो सकता है कि आप अपनी एनर्जी को वेस्ट करके समझोगे। तो क्यों करना चाहते हैं आप ऐसा? मैं आपका साथी हूं, मैं आपका दोस्त हूं, मैं आपको समझा रहा हूं, आप मेरी बात को समझिएगा। आप ऐसा मत कीजिएगा। इज दिस क्लियर? आप ऐसा नहीं करेंगे। अच्छा, कुछ लिखा है आपने? आशीष कुमार पांडे क्या लिख रहे हैं? अच्छा, टेक फ्यू रिवीजन क्लासेस। जी। हम्म। देखो, आप सपने देखते हो, सपने नहीं देखोगे तो मोटिवेटेड नहीं रहोगे। यू मस्ट ड्रीम, मस्ट ड्रीम। हम्म। ऑल राइट, ऑल राइट। MP notification is out. Read for MP. What is to be done for MP, by the way? I think MP exam is not very difficult exam. If you read that carefully now, um, I think you can do it. That's not a really very difficult examination. Is this clear? Is this all right? तो प्रिलिमिनरी की तैयारी कैसे करें इस पर तो मैंने काफ़ी बोला है, काफ़ी बार आप यूट्यूब पे वो देखना भी, आपको पता चल जाएगा. दैट्स नॉट ए बिग डील, नॉट ए बिग थिंग. So you can do it, that's nothing great. I think you will be able to do it. We'll discuss that again. That's not a problem at all. Today we are in this CPC class. Uh, uh, Most of you are saying that there is lack of motivation and there is lack of consistency. No. Third wave may be postponed, so final semester students should fill the form. Yes. Yes, we should. We don't know what will happen ahead, so I don't think that you should waste your energy and time in waiting. So, see, as far as any subject is concerned, you are talking of this MP examination. I'll reiterate the fact that you please look into previous question paper first. Take the questions on a piece of paper, be it objective and subjective. Take the piece of paper on a sheet, and then you will have the idea what kind of questions are there. You will have an idea. And the moment you have an idea, then you will have clarity, and then your preparation will be pinpointed. Otherwise, you will be now confused somewhere that what to do, what to study, what not. There are many questions come up in our mind, and we are really confused. And now, alleviation of this confusion and fears consume a lot of time. It consumes a lot of time. So clarify your points beforehand. आपको कुछ नहीं करना, बहुत सिंपल प्रिपरेशन है. पहले तो प्रिपरेशन को हवा मत बनाओ, बहुत सिंपल है. जुडिशरी का प्रिलिमिनरी निकालना बहुत सिंपल है. हमारा नहीं निकल रहा, हो सकता है. So that's my problem, but it doesn't mean that the exam is difficult. First you believe this. And anybody can pass the examination, I tell you. But the only thing is that you are required to follow the basic tricks and techniques. Previous year question लो, ढंग से पढ़ो उसको, concentration से पढ़ो. देखो, unless until you build understanding, you will never have memory. And if you do not have memory, you do not have understanding, you can never pass preliminary. तो ना तो आपको प्रिलिमिनरी पास कर पाओगे, ना कुछ कर पाओगे, तो फिर परेशान हो जाओगे. फिर परेशान हो जाओगे. इज दिस क्लियर? फिर परेशान हो जाओगे. दिस शुड नॉट हैपन. दिस शुड नॉट हैपन. इज दिस ऑल राइट? तो ये नहीं हो पाएगा. इससे आप थोड़ा सा समझ लेंगे इस चीज को. आप सीपीसी पढ़ने जा रहे हैं तो सीपीसी के सारे पीवाईक्यूज देख लो, खास करके एमपी के. देख लो कैसे क्वेश्चन आते हैं. थ्योरेटिकल आते हैं, एनालिटिकल आते हैं, केस बेस्ड आते हैं, ना मैक्सिम बेस्ड आता है, क्रक्स पे क्वेश्चन आता है, कॉन्सेप्ट पे क्वेश्चन आता है. किस चीज पे सवाल आ रहा है? टाइम फैक्टर है वहां पर, रिस्ट्रिक्शन है, कंडीशन है, लिमिटेशन है, किस चीज पर सवाल है? देयर कैन बी वैरायटी ऑफ क्वेश्चन. सेक्शन बेस्ड क्वेश्चन, विच सेक्शन कंटेन्स व्हाट. Concept based question हो सकता है. In order to rule 2, for the application of order to rule 2, what conditions are required? Is this clear? तो आप ऐसी चीजें कर सकते हैं. Is this all right? आप ऐसी चीजें कर सकते हैं. Is this clear? तो आप इसको करिए, देखिए, कोई बहुत बड़ी बात नहीं है, कोई बहुत मुश्किल की बात नहीं है. मुझे लगता है और कोई आपके दिमाग में भी सवाल नहीं है, आप बहुत क्लियर हैं. प्रिलिमिनरी का जो रिवीजन आप कह रहे हैं, आप करिए उसको, अच्छी बात है. हम लोग भी करेंगे क्लास में. विल ट्राई टू नाउ जस्ट सॉल्विंग द क्वेश्चन. अब देखिए, पिछले दिन आपने जैसे पढ़ा था, हमने पढ़ा था ऑर्डर 11 तक, मुझे जो ध्यान आ रहा है, ऑर्डर 12 पर हम चर्चा कर रहे थे, एडमिशंस पर। थोड़ा मोड़ा देखते हैं, सब सिंपल टॉपिक्स है, कोई बहुत डिटेल्ड एनालिसिस की जरूरत नहीं पड़ती इन टॉपिक्स में। यू कांट कंपेयर इट विद ऑर्डर 2 रूल 2 और ऑर्डर 6 रूल 7 ना, ऑर्डर 6 रूल 17, तो वो जरूरत नहीं है यहाँ पर। सो यू डोंट कंपेयर इट विद दोज थिंग्स, प्लीज बी केयरफुल अबाउट दैट. What kind of questions will come, I'll let you know, and accordingly we discuss in class. So let us see order 12. What does it say? What does it do? Notice of admission of case. Any party to a suit may give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of any other party. Any party to suit may give notice. किस चीज के लिए? A party to suit gives notice by his pleading or otherwise. A party to suit gives notice by his pleading or otherwise in writing that he admits the truth of whole or any part of the case of any other party. Admits the truth of whole. Or any part. A party to suit gives notice by pleading or otherwise in writing, admits the whole or the truth, admits the truth of whole or any part of the case of any other party. So, any party can give notice to the other party. Any party can give notice to the other party by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of any other party. So defendant can do it, plaintiff can do it. Now they can admit certain things. Now here it is written, now in this case Puspa Devi Bhagat versus Rajinder Singh. The apex court held that in case reply is not filed by the defendant in spite of giving opportunities in such a case, the necessary conclusion may be that defendant has admitted the plaintiff's claim and that the suit may be decreed on the basis of evidence and the implied admission made by the defendant. If you do not, you have been given opportunities to file reply, but you do not do it. So what will be deemed? If you do not contradict, if you do not deny, then it will be deemed to be admitted. Mangudas Ramdas versus Dalpat Ram Icharam. It was held that admission in pleading or judicial admission made by at or before the hearing of the case stands on a higher footing than evidentiary admission and are binding on the party making them and constitute waiver of proof. So there are two kinds of admissions: judicial admissions and evidentiary admissions. Judicial admissions are by pleading or now in trial, obviously, and this evidentiary admissions are before the case starts. That is in your talk or in your conversation, something like that, evidentiary admissions. The admissory evidences are not having that much value. So just see in the section 2, notice to admit document. Either party may call upon the other party. So always see what happens, I tell you, when the trial is done, then the trial is on the basis of certain issues and how the issues will arise. So if you can look into this, order 14, issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. Issues arise when a material proposition of fact or law is affirmed by one and denied by the other. Issues arise when a material proposition of fact or law is affirmed by one and denied by the other. So, issue will arise there where I say something, I've said that I have given you loan and you say that no, you have not given me loan, so there is issue between you and me, and then it will be decided. Issues arise when a material proposition of fact or law is affirmed by one and denied by the other. Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Each material proposition affirmed by one party and denied by the other shall form the subject of distinct issue. So, her material proposition, how much I have given the money, that may be in dispute. Whether I have given the money or not, that may be in dispute. If I have given the money, how much I have given the money, whether you have returned the money or not, that may be in dispute. So, that each material proposition affirmed by one party and denied by the other shall form the subject of distinct issue. Issues are of two kinds, issues of fact and issues of law. At the first hearing of the suit, the court shall, after reading the plaint and the written statement, if any, and after examination under Rule 2 of Order 10, and after hearing the parties or their pleaders, ascertain upon what material propositions of fact or law the parties are at variance, and shall thereupon proceed to frame and record the issue on which the right decision of the case appears. So at the first hearing, the court shall, after reading the plaint and WS, and if any, after examination under Order 10, Rule 2, and after hearing the parties, ascertain upon the what material proposition of fact or law the parties are at variance, and then they will frame the issue and then they will decide the case. So issue arises from where? Issue arises from this fact that you assert something and the other party denies something. That is how issues are raised. If I assert and you admit, then there is no issue. And that is why admission becomes very, very important. The fact admitted need not be proved. There is no issue. So if the facts are admitted, there is no requirement of proving the fact. If I say that I gave you 1 lakh rupees as loan and you accept that yes, you gave me 1 lakh rupees as loan, so where is the question of proving this fact? You have said I have admitted, so there is no issue. So is it to be decided by the court? No. It is already accepted by the party. Court will pass the judgment on that basis, on that admission. So this is how it acquires relevance. So in that context, it says notice to either party may call upon the other party to admit within 7 days from the date of service of notice any document. So you can ask the other party to, see this factual information is important for your preliminary 7 days. Serving all just exceptions, saving all just exception. And in the case of refusal or neglect to admit after such notice, the cost of proving any such document shall be paid by the party so neglecting or refusing, whatever the result of the suit may be, unless the court otherwise directs, and no cost of proving any document shall be allowed unless such notice is given, except where omission to give notice is, in the opinion of court, a saving of expense. So, one can give notice to other to admit documents. One can give notice to other to admit documents within 7 days from date of service. one can give notice to other to admit documents within 7 days from date of service. From date of service. And in case of refusal neglect to admit after the cost of proving any such document shall be paid with party so neglecting. If party neglects to admit document, then cost of proving that is to be then cost of proving that is to be borne by the party neglecting. Is to be borne by the party neglecting, whatever the result of suit may be, unless the court otherwise directs. Unless the court otherwise directs. And no cost of proving any document shall be allowed. No cost of proving any document shall be allowed unless such notice is given, where the omission to give the notice is, in the opinion of court, saving of expenses. So there is nothing great. So it only says this point that you can call upon the other party to admit the document within 7 days from the date of service. Now, saving all just exceptions. And if he does not admit the document within 7 days, then he will have to bear the cost of proving that document. Correctly so. Whatever the result of suit may be. Now, unless the court otherwise. And now, Sitaram Motilal Kalal, there is a case. Admission of document means admission of fact contained in the document. So, once you admit the document, you admit all the facts contained in the document. So, notice to admit documents, rule 2. Is this clear? Rule 1, notice of admission of case. You also see this. It is notice of admission of case. And this is notice to admit documents. So, this can be preliminary question. Then it says to a document to be deemed to be admitted if not denied after service of notice. The rule 2A. Deemed admission. Deemed admission. Document to be deemed to be admitted if not denied after service of notice to admit document. Every document which a party is called upon to admit, if not denied specifically or by necessary implication or stated to be not admitted in the pleading of that party or in his reply to the notice to admit document, shall be deemed to be admitted. Deemed to be admitted, except as against a person under a disability. So this is deemed admission. You can write down a little bit on this point also. If not denied specifically, if document is not denied specifically, or by necessary implication, or is stated to be not admitted or stated to be not admitted. Stated to be not admitted. So you state that I am not admitting this. Or stated to be not admitted. Stated to be not admitted. Then it will be deemed to be admitted. Then it will be deemed to be admitted. Just पढ़ने के लिए सब कुछ है नहीं. It will be deemed to be admitted. Except against a person under disability. A person under disability have exemption. Except as against a person under disability. All right? Where a party unreasonably neglects or refuses to admit a document after the service on him of the notice to admit document, the court may direct him to pay cost to the other party by way of compensation. Unreasonably neglects or refuses to admit. After service of notice, court may direct him to pay the cost. So, if somebody unreasonably neglects or refuses to admit a document, after the service of notice, the court may direct him to pay compensation. Court may direct him to pay compensation. ठीक है, तो ट्रिवियल रूल्स हैं, पढ़ें आप, इसमें कुछ है नहीं, कोई बहुत जरूरत नहीं है जानने का. Form of notice, form number 9 in Appendix C. Power of court to record admission 3A. Notwithstanding that no notice to admit has been given under Rule 2, the court may at any stage of the proceeding before it of its own motion, khud ba khud, on its own, call upon any party to admit any document and shall in such case record whether the party admits or refuses or neglects to admit such document. So this can be done by the court also. Court can ask the party to admit. Party can do, similarly court can do. So Rule 3A says, court at any stage on its own motion call upon party to admit document and shall in such a case record may call upon and shall in such case record whether party admits or refuses to admit such document. Rule 3A. Quote, at any stage, on its own motion, apne aap, may call upon the party to admit document. It can also ask the party to admit document. But if it's asked, then shall in such a case record whether the party admits or refuses. So that has to be recorded. If you call upon the party to admit, then you have to record this. Is this clear? Notice to admit facts. Now see, first was notice to admit case, second was notice to admit document, now it is notice to admit fact. Any party by notice in writing at any time not later than 9 days before the day fixed for hearing call upon other party to admit for the purpose of the suit only and any specific fact or facts mentioned in such notice, and in case of refusal or neglect to admit the same within 6 days after service of notice or within such further time as may be allowed. Notice to admit facts. Rule 4. Notice to admit facts. Any party by notice in writing at any time not later than 9 days before the day fixed for the hearing call on any other party to admit for the purposes of the suit any specific fact or facts. Any party may by notice in writing at any time any party may by notice in writing at any time not later than before the day fixed call on any other party to do what? To admit facts. देखो फैक्ट्स के एडमिशन का रूल 4 अब ये प्रिलिमिनरी में सवाल आया हुआ है विच रूल टॉक्स ऑफ विच एडमिशन by notice in writing at any time not later than 9 days before the day fixed for the hearing. To admit the same within 6 days after service of notice. 6 days within service of notice. Six days within service of notice. तो नोटिस देखो, अब रूल 1 2 3 अब ध्यान रखना, प्रिलिमिनरी की पढ़ाई का यही तरीका है। रूल 1 में क्या पढ़ा हमने, कोई भी चीज़ इससे नहीं आएगा आपको, इतना इम्पोर्टेंट भी नहीं है, बट एडमिशन इम्पोर्टेंट है ऐसे। रूल 1 इज केस, और रूल 2 इज डॉक्यूमेंट, and rule 3 is or rule 4 is fact. Is this clear? जजमेंट एंड एडमिशन जो सबसे इम्पॉर्टेंट है, रूल 6, हमें इसी को समझना है, रूल 6 को। जजमेंट और एडमिशन, थोड़ा इसको देखिए, ये बहुत इम्पॉर्टेंट चीज़ है। हिमानी एलॉयज, रजिया बेगम, कैन यू सी दिस? नागूभाई अम्बल वर्सेस बी सामा रोड एंड अदर्स। थोड़ा देखिएगा, जजमेंट ऑन एडमिशन, ऑर्डर 12 रूल 6। where admission of fact have been made either in the pleading or otherwise. मैं 5 मिनट के लिए रुक जाऊं क्या, फिर पढ़ूं ऑर्डर 12 रूल 6, तो ठीक रहेगा, क्योंकि ऑर्डर 12 रूल 6 एक रिदम में पढ़ना पड़ेगा। मेरे को 5 मिनट का ब्रेक दे दो तो ठीक रहेगा, मैं थोड़ा, क्योंकि ऑर्डर 12 रूल 6 इज वेरी वेरी इंपॉर्टेंट। देन आई कवर ऑर्डर 12, ऑर्डर 13 एंड 14 ऑल्सो क्विकली, उसमें कुछ है नहीं। Now order 12 rule 6, which is the most important rule. Now let us see what is this. It says, where admission of fact have been made either in the pleading or otherwise, whether orally or in writing, the court may at any stage of the suit, either on application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it thinks fit, having regard to such admission. So it says, where admission of fact have been made either in the pleading or otherwise, court may at any stage of the suit, either on application of party or on its own motion, without waiting for determination of any other. Now, there may be many questions involved. We are not concerned. On the point on which you have given admission, on that point the court will give judgment. So, if there are many issues in the case, 4, 5, and you have admitted something on one issue, so on that issue, the court can give judgment. So, on this point, you are required to generate some literature so that if you get a question, you may write on that question. So, that is what is required. You please write down that as per order 12 rule 6, as per order 12 rule 6, as per order 12 rule 6, court at any stage of suit, court at any stage of suit, court at any stage of suit may give judgment, may give judgment, may give judgment may give judgment or may make such order, or may make such order as it thinks fit. Or may make such order as it thinks fit. Or may make such order as it thinks fit. May make such order as it thinks fit. May make such order as it thinks fit. All right? All right? Now, on this point, you can write down further. On this basis, a decree can also be drawn up. A decree shall be drawn up, rather. A decree shall be drawn up. A decree shall be drawn up in accordance with the judgment. A decree shall be drawn up in accordance with the judgment. Imani Alloys Limited versus Tata Steel Limited. Imani Alloys Limited versus Tata Steel Limited. Order 12, Rule 6. Imani Alloys Limited versus Tata Steel Limited. Now, in this case, the court said, Order 12, Rule 6 says, Order 12, Rule 6 says, an enabling provision. Order 12, Rule 6 says, Order 12, Rule 6 says, an enabling provision. Order 12, Rule 6 is an enabling provision. It is neither mandatory. It is neither mandatory nor preemptory. It is neither mandatory nor preemptory. It is neither mandatory nor preemptory, but discretionary. It is neither mandatory nor preemptory, but discretionary. But discretionary. But discretionary. But discretionary. The court on examination of facts and circumstances, court on examination of facts and circumstances has to exercise Court on examination of facts and circumstances has to exercise its judicial discretion. Court on examination of facts and circumstances has to exercise its judicial discretion. Its judicial discretion. This discretion will be exercised. This discretion will be exercised keeping in mind. This discretion will be exercised keeping in mind that judgment or admission is a judgment. Judgment on admission is a judgment without trial. Is a judgment without trial, which permanently denies any remedy, to the defendant, by way of an appeal, on merits. By way of an appeal on merits. Which permanently denies any remedy to the defendant by way of appeal on merits. So, it is the duty of court So, it is the duty of court to see that. So, it is the duty of court to see that the admission is clear, unambiguous, and unconditional. So, it is the duty of court to see that admission is clear, unambiguous, and unconditional. Admission is clear, unambiguous, and unconditional. The discretion of court should not be exercised. The discretion of the court should not be exercised. The discretion of the court should not be exercised to deny the valuable right. The discretion of the court should not be exercised to deny the valuable right of defendant. The discretion of the court should not be exercised to deny the valuable right of defendant to contest the claim. The discretion of the court should not be exercised to deny the valuable right of defendant to contest the claim. To contest the claim. In short, discretion should be used. In short, discretion should be used only when there is clear admission. Only when there is clear admission. Only when there is clear admission. In short, discretion should be used only when there is clear admission. अब एडमिशन कैसे होते हैं? अब ये तो हिमानी लॉज तो देख लिया ना आपने, इसमें कुछ है नहीं खास। कह रहा है कि ये डिस्क्रेशनरी पावर है, 2011 का डिसीजन है ये। उसके बाद एक केस है, ये देखो कह रहे हैं लोकस क्लासिकस है ये, नागू भाई अम्मल एंड अदर्स वर्सेस बी सामा रोड एंड अदर्स। नागू भाई, नॉट भाई। नागू भाई अम्मल वर्सेस बी सामा रोड एंड अदर्स। AIR 1956, Supreme Court 593। Merely because of written admission was made in a different context, such admission may not become relevant if the party making it has a reasonable explanation of that. So you can write down, it says, merely because of written admission was made in a different context, such admission may not become relevant if the party making it has a reasonable explanation if the party making has a reasonable explanation of that. Merely because of written admission made within different context, such admission may not become relevant. May not become relevant if the party making it has reasonable explanation of that. The Apex Court further said the Apex Court further said that an admission is not conclusive as to the truth of matter is stated therein. As to the truth of matter stated therein. It is only a piece of evidence. It is only a piece of evidence. It is only a piece of evidence, the weight to be attached to which must depend. This is important. This is locus classicus, one of the most important decisions. This decision will answer all your query regarding Order 12, Rule 6. And Order 12, Rule 6 is the only important rule in this. Rest is important for preliminary. A piece of evidence, the weight to be attached to which must depend on the circumstances under which it is made. Under which it is made. It can be shown to be erroneous or untrue so long as the person to whom it was made has not acted upon in his detriment, when it might become conclusive. This is very important. It can be shown to be erroneous, means wrong, or untrue, that it was not correct, so long as person to whom it was made has not acted upon. Now, moment he acts upon this, then this is different story. Has not acted upon it in his detriment. In his detriment. All right. When it might become conclusive. When it might become conclusive. By way of estoppel. By way of estoppel. I think you have no query. It might become conclusive by way of estoppel. This is relevant. You can read the entire thing. You can read the entire thing, my dear friend. And then there is another case, Razia Begum versus Sahebzadi Anwar Begum, 1958 Supreme Court. These cases clarify all point on Order 12, Rule 6. This is very important in practice, by the way. It is very important in court. Razia Begum versus Sahebzadi Anwar Begum. (1958) Supreme Court, 886. Razia Begum versus Sahebzadi Anwar Begum. Now, in this case, what happens? Now, it says Order 12, Rule 6. Order 12, Rule 6 should be read along with should be read along with proviso. Order 12, Rule 6 should be read along with proviso to Rule 5 of Order 8 CPC. Order 12, Rule 6 should be read along with proviso to Rule 5 of Order 8 CPC. Now, you can see this also. You just see what is this. Order 8, Rule 5, proviso. What is this? Order 12, Rule 6 तो आपने देख लिया कि एडमिशन के बेसिस पर जजमेंट दिया जा सकता है. ठीक है. अब ये ऑर्डर 8 का रूल 5 का प्रोवाइजो क्या है जरा देख लें. Let us have a look. Specific denial. Court provided that court may not require any fact so admitted to be proved otherwise than by such admission. So court may require the proof of admission. Even if you have admitted, court may not rely upon that, and court may ask you to prove it further, even if you have admitted. So, court is not bound. Court is not bound Court is not bound to grant a declaration. Court is not bound to grant declaration prayed for on the mere admission of claim should be read along with proviso to Rule 5 of Order 8 CPC. Court is not bound to grant a declaration prayed for on mere admission of claim. So, on mere admission of claim, court is not going to grant any relief. If the court has reason, to insist upon, a clear proof apart from admission. Sir जी at what number page है रजिया केस देख लीजिए भाई. नहीं होगा तो लिखेंगे आगे, मैं तो कोई आर्टिकल देख रहा हूँ। रजिया बेगम वर्सेस साहबजादी अनवर बेगम, देख रहे हैं, कोर्ट इज नॉट बाउंड टू ग्रांट डिक्लेरेशन पीरियड फॉर ऑन मेयर एडमिशन ऑफ क्लेम बाय डिफेंडेंट इफ द कोर्ट हैज रीजन टू इंसिस्ट अपॉन ए क्लियर प्रूफ apart from admission. Nagu Bhai Ammal versus B Sama Road and others is not there. We'll add it here, no issue. Later on. This is main point सारे इससे मिल जाएंगे. Court in Razia Begum's case further observed, it is also clear on the words of statute quoted above that grant of declaration such as contemplated by section 42 is entirely in the discretion. This is talking of a specific relief act, no? At this stage, it is convenient to deal with other contention raised on behalf of Napoli, that is in view of unequivocal admission of plaintiff's claim by the prince in his written statement and repeated as aforesaid in his counter to the application for intervention. It is suggested that declaration sought in this case should be granted as a matter of course. In this connection, our attention was called to the provision of Order 12 Rule 6, which lays down that upon such admission as have been made by the prince in this case, the court would give judgment for the plaintiff. This provision have got to be read along with Order 8 Rule 5 proviso. All right, this is the repetition of what we have learnt. So nothing great in this. Nothing great in this. So this is Rajia case. Now then any other point? Let me check. Nagubai versus B. Samarao, I have already said. And admission in civil cases of what kind of? So I just for your information, it may be relevant for preliminary admission in civil case. Are spread in 3 parts. Actual admission, oral or by document, express or implied admission, by pleadings. Actual admission, oral or by actual admission, जो आपने actually किया. Now you are admitting certain fact that I have to give this much money to you. Express of implied admissions by pleading, which is there in your pleading. Implied admissions can also, if you do not deny, then it is deemed to be admitted. Or you can expressly admit that I admit this fact to be correct. Then it is by agreement or by notice. This is the third method. By agreement or notice. क्लास में साउंड की प्रॉब्लम तो नहीं है? क्लास में साउंड की प्रॉब्लम तो नहीं है? क्लास में कोई साउंड की प्रॉब्लम तो नहीं है? देख लो भाई, कोई बोल रहा था। तो ऑर्डर 12 रूल 6 तो यही है, यही इंपॉर्टेंट था आपके, इसमें और कुछ तो है नहीं इसमें। ऑर्डर 12 में कुछ तो नहीं। 13 में प्रोडक्शन, impounding एंड रिटर्न ऑफ डॉक्यूमेंट, ओरिजिनल डॉक्यूमेंट्स टू बी प्रोड्यूस्ड एट और बिफोर द सेटलमेंट ऑफ इशू. The parties or their pleaders shall produce on or before settlement of issues all the documentary evidence in original where the copies thereof have been filed along with the plaint or written statement. So parties will be asked to produce before settlement of issue. Settlement of issue is there in order 14. All documentary evidence in original. अब आपको original देना, where the copies have been filed along with the plaint or WS. The court shall receive the documents so produced, provided they are accompanied by an accurate list thereof prepared in such form as the High Court directs. High Court can make rule regarding this, so that is what is there. Nothing in sub rule 1 shall apply to documents produced for the cross examination of the witnesses of the other party, handed over to a witness merely to refresh his memory. Nothing in sub rule 1 shall apply to documents. So it says, see, it says that this order 13 rule 1 says original to be produced. Nothing in sub rule 1. All the documents in original, produced for cross examination. So here original is not required. Handed over to witness to refresh his memory. So parties are required to produce original of all documentary evidence that are there in possession, but this rule shall not apply to the following documents. So this can be a good preliminary question. देखो ऐसे ही सवाल एग्जाम में आते हैं ना. This will, no, original will be asked, but no, not in all cases. It is not in case of cross examination or for refreshing the memory. Rejection of irrelevant and inadmissible documents. Yes, court may at any stage of the suit reject any document which it considers irrelevant or otherwise inadmissible, recording the ground of such rejection. All right. Endorsement on documents admitted in evidence. Subject to the provision of the next following sub-rule, there shall be endorsed on every document which has been admitted in evidence in the suit the following particulars. क्या क्या उसमें डालना है? Number and title of the suit, name of the person. These are relevant for your practice, etc. The date on which it was produced, a statement of having been so admitted. Endorsement shall be signed or initialed by the judge. Endorsement on copies of admitted entries in books, accounts, and records. So these are just necessary details, nothing important here for examination as such. ये सब एग्जाम के लिए रेलिवेंट नहीं है, बट आप पढ़िए एक सर कर्सरी निगाह से. अब देखिए, आप कहेंगे कि सर ने ये नहीं पढ़ा. ये हमारे पढ़ाने की चीज नहीं है. हमने आपको बता दिया रूल 1, ऑर्डर 13 रूल 1 थोड़ा रेलिवेंट है. वही आपको ओरिजिनल लाना है, बट ये ओरिजिनल वाला रूल ये क्रॉस एग्जामिनेशन एंड रिफ्रेशिंग मेमोरी में नहीं लगता. अब मैं ऑर्डर 13 रूल 3 में क्या बताऊं? कोर्ट में एनी स्टेट्स रिजेक्ट एनी डॉक्यूमेंट व्हिच इज कंसीडर्ड इररिलेवेंट. इररिलेवेंट है तो रिजेक्ट करेगा. अदरवाइज इनएडमिसिबल. इफ इट इज इनएडमिसिबल इन एविडेंस लॉ, इट विल नॉट एक्सेप्ट दैट. सो नथिंग टू बी टॉट हियर एज सच. हर चीज को एक ही निगाह से मत देखने लगना कि ऑर्डर 13 में सर ने सारे रूल नहीं पढ़ाए. अब आप मुझे परेशान मत करना इसके लिए. ये पढ़ाने की जरूरत नहीं है, ये पढ़ने की चीजें हैं. आप खुद से पढ़िए डायरेक्ट. ठीक है ना? क्लियर है? Is this all right? Is this clear? बोलो भाई. Is this all right? नहीं पता चल रहा है. आपकी बातें पता नहीं चल रही है. Keeping document in custody of court. Yes, you can say like that. You can say like that, my dear friend, and nothing great here. Nothing great here. Taking custody of the document, that is seizing the document. और तो कुछ है नहीं इसमें कि जो मैं आपको बताऊं. बताने लगा है? मुझे तो नहीं लगता भाई. बहुत दिन के बाद क्लास में आने पे आपको भी बड़ा अनोखा सा लगता नहीं? हमें भी बड़ा अनोखा सा लग रहा है. मैं भी पूरे रिदम में नहीं आ पाया आज. आई फील लिटिल बिट concerned. I could not come in rhythm, so I think that I have not been able to do great justice to this class, because there is frequent looking to now here and there messages, and then this distraction all the time. So I'll try to do it tomorrow, because I'll be going to doctor right now. I have got appointment with my doctor for eyes, so I'll be going there. Don't worry, I'll join you tomorrow, my dear friend, and I'll do better. So don't worry. So if I have done anything wrong, please excuse me for that. Is this all right? Is this all right? So can I take your leave today? I'll see you tomorrow. क्या भाई आशुतोष जी, हमको थोड़ा सा कल मिलते हैं ना, कल पढ़ाएंगे फिर आगे मजा आएगा. अरे आज तो मैंने कुछ पढ़ाया ही नहीं. हमने तुम्हें केवल ऑर्डर 12 रूल 6 पढ़ाया. ऑर्डर 12 रूल 6 में जितना मैटर बताया उसी को ध्यान से देखना है. इज दिस क्लियर? इज दिस ऑल राइट? चलिए कल मिल लेते हैं, पढ़ लेंगे आगे की और कल. फिर मैं थोड़ा डॉक्टर के पास जाऊंगा, मेरा अपॉइंटमेंट है अभी.